As every law student is taught, the common law develops incrementally on a case-by-case basis. However, some areas of the common law develop more quickly than others. The law of negligence, as it applies to public authorities, is one aspect of the common law which has seen significant development, in particular in a run of 3 cases in the Supreme Court in the second half of the last decade. Perhaps because there is an almost infinite supply of potential factual scenarios to which allegations of negligence may be levelled at public authorities, the cases continue to come thick and fast. The latest instalment is the case of Tindall and the Chief Constable of Thames Valley Police, a decision of the Court of Appeal handed down in January of this year, in which the court allowed an appeal against the decision of Master MacLeod to refuse the Chief Constable's application to strike out the negligence claim brought by Mrs. Tindall. In this seminar, I intend to look in detail at that decision and the reasoning of the court, and to analyse where the decision fits within the direction of travel shown by the recent case law. The facts of Tindall are tragic. Mrs. Tindall sued as the personal representative of her late husband Malcolm, who died in a head-on collision in March 2014 when the vehicle he was driving hit a patch of black ice on the road. He lost control and came into a head-on collision with another driver, Mr. Bird. Both men were killed. Around an hour prior to Mr. Tindall's accident, another driver, a Mr. Kendall, had slid off the same part of the road on the same black ice and suffered injuries. Mr. Kendall worked as a road gritter locally, and he was concerned that others might suffer the same fate as he had. Whilst waiting to be rescued and attended by an ambulance, he stood by the road and warned other oncoming vehicles to slow down. Around 20 minutes after Mr. Kendall's accident, the police arrived at the scene. They put up a "Please slow" sign and removed the debris from the road. They stayed for around 20 minutes, and whilst they were there, an ambulance attended which took Mr. Kendall away to hospital. It was accepted for the purposes of the application that if the police had not attended, Mr. Kendall would have continued to warn road users of the dangers of black ice, and it was also accepted that the police did nothing to positively encourage or compel Mr. Kendall to leave the scene in the ambulance. After Mr. Kendall had gone off to hospital, the police left the scene, taking their sign with them and taking no further steps either to make the road safe or warn drivers of any impending danger. It was around 20 minutes after the police left that Mr. Bird and Mr. Tindall came into collision. Before we look at the way in which Mrs. Tindall put her claim, it's useful to remind ourselves of an important distinction the law makes in the field of negligence liability between acts and omissions, and what has been termed the duty not to make things worse and the duty to protect someone from harm. Since the House of Lords decided the case of East Suffolk Rivers Catchment Board and Kent in 1941, 3 propositions have been settled law. First, that public authorities are to be treated no differently to private individuals for the purposes of the law of negligence. Second, generally, and subject to some important exceptions which have been developed through the case law, person A is not subject to any duty to take care to prevent harm occurring to person B through a source of danger which is not created by person A. And third, where an individual or public authority comes across a source of danger which it has not created, but performs a positive act which makes that danger worse, it will be liable in the tort of negligence for harm caused by its actions in making that danger worse. The limitations of the duty not to make things worse was made clear in the East Suffolk case. In that case, a sea wall was breached at high tide, which caused flooding to the plaintiff's land. The defendant authority undertook repairs to the wall, which took 178 days to complete, but which, the trial judge held, could have taken only 14 days if the public authority had been so minded. In holding that the claim against the authority for the damage suffered as a result of the delay to the repair was bad, the House of Lords held that where, in the exercise of its discretion, a public authority embarks upon execution of a power to act, the only duty owed to members of the public is to not thereby add to the damage which the person would have suffered if the authority did nothing. That is the limit of the duty. Mrs. Tindall claimed that the Chief Constable, who was vicariously liable for the acts of their officers who attended shortly before her husband's accident, was in breach of his duty not to make things worse and his duty to protect Mr. Tindall from suffering harm. The allegation of the breach of duty not to make things worse was that the actions of the police in attending the accident led to Mr. Kendall leaving the scene, and that if Mr. Kendall had stayed, it was likely that he would have warned drivers to slow down as they came past, including Mr. Tindall, and so the fatal accident would have been avoided. So Mrs. Tindall said, the attendance of the police made things worse. The allegation of breach of the duty to protect Mr. Tindall from harm encompassed several allegations, including a failure to conduct a risk assessment, a failure to take steps to slow traffic down, a failure to take all reasonable steps to get a gritter to attend prior to Mr. Tindall's fatal accident, failing to stay at the scene, and failing to close the road. As can be seen, all of these allegations were allegations of omission. The Court of Appeal conducted a thorough survey of the authorities in the area, including a very useful analysis of the trilogy of cases heard in the Supreme Court in the mid to late 2010s. Michael and the Chief Constable of South Wales Police in 2015, Robinson and the Chief Constable of West Yorkshire Police in 2018, and N and others and Poole Borough Council in 2019. The focus in all of those cases was on the exceptions to the general rule that person A is not liable for preventing harm to someone which arises from a source of danger they didn't create. In Robinson, Lord Reid had cited with approval the following pithy summary taken from a 2016 article by Stelios Tafaris and Sandy Steele, published in the Cambridge Law Journal. And I quote, "In the tort of negligence, a person A is not under a duty to take care to prevent harm occurring to person B through a source of danger not created by A unless 1. A has assumed a responsibility to protect B from that danger. 2. A has done something which prevents another from protecting B from that danger. 3. A has a special level of control over that source of danger. Or 4. A's status creates an obligation to protect B from that danger." The issue of assumption of responsibility was at the forefront of the court's consideration in the case of Poole. In that case, two children had been placed together with their mother by the local authority in a property under its powers as a housing authority. The property into which they were placed was located next to a family which the local authority knew was liable to behave in an antisocial and harassing manner. The claim of the children for damages suffered as a result of the behaviour of the neighbouring family failed, because, as Lord Reid put it, and I quote, "The assumption of responsibility is an undertaking that reasonable care will be taken, either express or more commonly implied, usually from the reasonable foreseeability of reliance on the exercise of such care," close quotes. Lord Reid found that in placing the children in the property, the local authority was not assuming responsibility to provide its service of housing provision with reasonable care. His reasoning was rooted in the absence of reliance, and I quote, "In the present case, on the other hand, the Council's investigating and monitoring of the claimant's position did not involve the provision of a service to them on which they or their mother could be expected to rely. It may have been reasonably foreseeable that their mother would be anxious that the Council should act so as to protect the family from their neighbours, in particular by rehousing them, but anxiety does not amount to reliance. Nor could it be said that the claimants and their mother had entrusted their safety to the Council, or that the Council had accepted that responsibility. Nor had the Council taken the claimants into its care and thereby assumed responsibility for their welfare." Close quotes. In Tindall, the Court of Appeal gathered together the principles in relation to the negligence liability of public authorities in what I think is likely to prove a user-friendly and oft-cited passage. They said as follows: 1. Where a statutory authority, including the police, is entrusted with a mere power, it cannot generally be made liable for any damage sustained by a member of the public by reason of a failure to exercise that power. In general, the duty of a public authority is to avoid causing damage, not to prevent future damage due to causes for which they were not responsible. 2. It follows that a public authority will not generally be held liable where it has intervened, but it has done so ineffectually, so that it has failed to confer a benefit that would have resulted if it had acted competently. 3. Principle 2 applies even where it may be said that the public authority's intervention involves it taking control of operations. 4. Knowledge of a danger which the public authority has power to address is not sufficient to give rise to a duty of care to address it effectually or prevent harm arising from that danger. 5. Mere arrival of a public authority upon or presence at a scene of potential danger is not sufficient to found a duty of care, even if members of the public have an expectation that the public authority will intervene to tackle the potential danger. 6. The fact that a public authority has intervened in the past in a manner that would confer a benefit on members of the public is not of itself sufficient to give rise to a duty to act again in the same way. 7. In cases involving the police, the courts have consistently drawn the distinction between merely acting ineffectually and making matters worse. 8. The circumstances in which the police will be held to have assumed responsibility to an individual member of the public to protect them from harm are limited. It is not sufficient that the police are specifically alerted and respond to the risk of damage to identified property or injury to members of the public at large or to an individual. 9. In determining whether a public authority owes a private law duty to an individual, it is material to ask whether the relationship between the authority and the individual is any different from the relationship between the authority and other members of the same class as the individual. Mrs. Tindall relied heavily on a Scottish case, Gibson and All. In that case, following a bridge collapse after heavy rainfall, the police attended and coned off the north side of the bridge, illuminating their headlights and the blue lights of their vehicle so as to warn those approaching from the south side. However, the police did not take any steps to cone off the south side of the bridge and left the scene. A passenger in a car which drove off the edge of the south side of the bridge sued. The Lord Ordinary held that a duty of care was owed to the passenger in those circumstances, relying upon an analysis rooted in the Caparo and Dickman test, and in particular, the Lord Ordinary's view that the police had assumed responsibility for the safety of the road either side of the bridge upon their attendance. Now, it's difficult to see how this decision in Gibson and All could be squared with the duty not to make things worse, or the circumstances in which public authorities may be held to have assumed responsibility that they will perform their functions with reasonable care, as was explained and clarified by the Supreme Court in the trilogy of cases I have referred to. That too was the view of the Court of Appeal in Tindall. They disapproved Gibson and All, and with it probably went Miss Tindall's best point. When it came to the application of the law to the facts in Tindall, the Court of Appeal held that the master had been wrong not to strike out the claim. Even taking the facts at their height, there could be no duty of care owed by the Chief Constable. In relation to the allegation of breach of the duty not to make things worse, the Court of Appeal found that the mere attendance of the police was insufficient to establish such a breach. On the facts, the police had done nothing to persuade or compel Mr. Kendall to leave the scene, and so could not be held liable for the consequences of his leaving. As to the claim based on the breach of the duty to prevent harm, the Court of Appeal held that on conventional principles, these were allegations of a failure to take care to prevent harm caused by a danger created by someone other than the Chief Constable. The general rule, therefore, was that no duty arose. The Court of Appeal explicitly rejected the submission made on behalf of Mrs. Tindall that a duty could be imposed where the police had the power to exercise physical control over the accident locus, but failed to do so. None of the established exceptions to that general rule applied in this case. So what of the direction of travel? Well, we now have a clear framework within which the courts are to decide whether a public authority owes a duty of care to members of the public. The touchstone remains that, save in closely limited circumstances set out by the case law, a public authority will owe no duty to members of the public to prevent them from suffering harm which the public authority did not create. The exceptions to that general rule are likely to provide fertile ground for future litigation. For instance, Lord Reed's explanation of the role of reliance in analysing whether a public authority has assumed responsibility to provide a service with reasonable care appears to me to be an aspect which needs further clarification. However, there is no doubt that Tindall represents a clear restatement of the general principle. It also provides useful guidance on the duty not to make things worse, and for the lawyers, it gives us, in the 9-principle checklist in paragraph 54, a handy précis of the principles which have been developed in the law in this area over the last 100 years. Thank you very much.